All right, so my name is Cindy Dyer. I'm one of the attorneys with the Texas Legal Services Center Child Welfare Team. And again, welcome to our third in our six-part series of webinars. What we're trying to do with these webinars is put on information and education that we get regularly asked about from kinship caregivers across the state. And today's webinar is building on our webinar that we did last month. And both the first two webinars and this one will be available. The first two already are available on TLSC's YouTube channel, which you can find from our website. Um, all right, just a little bit about us for those of you who haven't worked with or don't know about TLSC. We are a statewide nonprofit organization. We are a legal aid provider, and we provide legal advice, advocacy, representation, and education to people across the state in more than a dozen civil law practice areas. Most of our work impacts low-income Texans. As I said, this is the third in our six-part webinar series. These are set on the third Wednesday of each month at the noon hour through August, with our next one scheduled for June 17th. And you can sign up for the remaining webinars or view completed webinars on our YouTube link, which is accessed from TLSC's website, tlsc.org. Our child welfare team is comprised of 6 attorneys and a social worker. We do a variety of legal work, all within the child welfare issue areas. We manage both the family helpline, which I'm going to explain more towards the end, as well as the Kin Care Project, which again, I'll explain more towards the end. Today's agenda is two-part. First, I'm going to lay out the standard legal options at the conclusion of a temporary managing conservatorship case. A reminder that a temporary managing conservatorship or a TMC case is when CPS removes children from the parents and a judge orders temporary conservatorship to CPS. These cases have a statutory deadline, and the temporary portion of that case has to be concluded before the deadline, which we'll go through more in a minute. The second part is discussing the financial and other public benefits options provided by DFPS that can be very different depending on adoption or who is named conservator in the child. And just so you know, for this presentation, I use DFPS and CPS and the department interchangeably. The correct agency is the Texas Department of Family and Protective Services, or the department. CPS is the program underneath DFPS that handles TMC cases. And again, I'm going to be using TMC and PMC all the time throughout this presentation as abbreviations. TMC, again, is temporary managing conservatorship, and PMC is permanent managing conservatorship. On this next slide, we have a super brief and optional survey for those of you willing to take it, which you can do on your computer or phone. There's just 3 questions before and the same 3 questions after, measuring what's been learned, if anything, from this webinar. The goal of these questions is to include those results in our grant reports so we can continue receiving funding to put out webinars and trainings like this for kinship caregivers. The final survey, again, just the same 3 questions, should take no more than 1 minute at the end. And so we're just going to allow for that right now. You can just scan this QR code or go to slido.com and enter that for the 3 questions. I'll just pause here for 1 minute. Okay, and you can continue to use that code. We appreciate you taking that. It's just a request of one of our funders. All right, so before getting into the next slides of what the options are at a termination trial, I'd like to first go over when these trials happen. Again, we're talking about children who are in the temporary managing conservatorship of the department. And so at the initial hearing, initial permanency hearing, which is set about 6 months into every TMC case, the CPS court must set a final hearing, and that hearing must be set before the existing statutory deadline. That final hearing is specifically for the court to render a final order. And so this hearing is called different things in different counties. It's also known as a merit setting or a trial. And in Texas, parties can ask for a jury trial instead of having that final hearing in front of a judge. The important thing to understand is that there must be resolution of a TMC case before that statutory deadline is reached. And in Texas, there's a hard limit to how long a TMC case can last. That doesn't mean there's a hard limit on children being in CPS custody. It's just that the temporary would need to turn to permanent because of that statutory deadline. I want to briefly go over TMC statutory deadlines because there is confusion. Texas law is set up so that a permanent decision is made on the case within a year after removal due to this statutory deadline. This is very different from other states' laws who don't operate under the same statutory deadlines. In Texas, there is a 1-year statutory deadline initially on TMC cases. The CPS judge can also grant a one-time 6-month extension on top of that deadline for what's called extraordinary circumstances. And extraordinary circumstances are not defined in the family code. It's left up to the judge. So if that extension is granted, the trial settings or final hearing are pushed back closer to the end of the new deadline, which is 18 months after TMC was initially ordered. If the children are sent home to the parents during a TMC case, it's called a monitored return or return and monitor. And that also extends the deadline for 6 months from the date that return starts. And then if the return doesn't go well and the judge issues a failed return and monitor and removes the children from the parents' home again, all while CPS still has temporary custody, that again extends the deadline for 6 months from the date the return was failed. So it's possible in some very rare situations that a case stays in the TMC phase for 2+ years without a resolution. That can be done if there's the regular year-long deadline, a 6-month extension ordered, a monitored return order with a new 6-month deadline, and a failed return, which could run that case 2.5 years if done in that order. Transparently, though, that's incredibly rare. What we want people to understand from this is that there is a hard stop to the length of time children can stay in the temporary custody of CPS in Texas. Every case has a different deadline, and that deadline is important to know because that is when the final resolution must occur by. It's also important to understand that if the children aren't returned to one or both parents, then either the parties need to reach agreement about what happens before that final hearing date, or a judge or jury will make the decision about the permanent custody of the children and the parents' parental rights. So before getting into this slide, which is option 1 of the 3 options we're going to go over, I'll note that what we're not talking about today are the scenarios of if a child is returned to a parent before the final hearing and the CPS case is full out dismissed, or if a child is returned to one parent and the court enters modified or agreed custody orders only involving the other parent. We aren't going to discuss that today simply because those don't involve a non-parent like DFPS or a relative like a kinship caregiver taking permanent custody or adoption, which is the point of what this webinar is. So we're going to go over the 3 big options that can happen at a trial or a final hearing, resulting in custody to somebody besides the parent. And the first option is termination of parental rights for all parents of a child. In Texas, a child cannot be adopted unless all parents' rights are terminated. And in a TMC case filed by CPS, it's pretty uncommon for the department to seek termination of only one parent's rights because a child cannot be adopted unless both parents' rights are terminated. Not to say it's never happened, right? The only times I've seen it happen, it's the facts have been pretty extreme against the parent who CPS seeks termination of, and the parent whose rights are not terminated is often in support of the termination CPS is seeking. So now, if rights are terminated, right, there's a final order after that hearing or trial that is signed, terminating those parental rights under certain grounds in the family code. And since the parents no longer have rights, somebody else has to be awarded custody of the child. And that custody can be given to either DFPS or to a non-parent. If the plan on the case is adoption, either by a relative, a kinship caregiver, an unlicensed or an unrelated foster home of anybody, right? If the plan is adoption, the children are placed in the permanent managing conservatorship of DFPS while they're awaiting adoption. In Texas, adoption cannot occur until at least 90 days has passed after the termination order is signed because of the specific statute that I've cited on the slide, Texas Family Code 102.006. This is a law about very narrow standing for non-parents who can file a case after termination of parental rights. If you are in this scenario, feel free to call the helpline and we can walk you through what the options are. The important thing to understand is that termination results in the loss of all legal standing for parents. Standing is the right or ability to file a court case, and that is stripped from a parent when their rights are terminated. So they can't file a court case about their biological child anymore if they're no longer the legal parent. So meaning that unless the parents win an appeal or later have their rights reinstated, they can never file a case about custody or visitation or anything else to do with that child again. Adoption can also not occur if an appeal is pending from those termination of parental rights. Any parent has the right to an accelerated appeal if their parental rights are terminated. They have to file that notice of appeal within 20 days of that termination decree being signed. And in Texas, these termination appeals are accelerated to give resolution to families, hopefully sooner rather than waiting years. It can take several months to a year, if not longer, depending on delays in briefing, but the adoption has to wait to see if the terminations are overturned. If those terminations are upheld after someone appeals, the children are available for adoption, as long as everything is clear on the licensing. Of note here is sometimes parents' rights will be terminated and there's no adoptive placement. Those children also go into the permanent managing conservatorship of CPS. Although there should be pushback on those situations if there's no one waiting who can care for that child, because then you've just made that child a legal orphan with CPS as their parents, with no other options, right? But I just wanted to bring in here that this section can include termination of parents' rights and giving PMC to a non-parent as well, without going into the permanent custody of DFPS. I talk about that in 2 slides. Option number 2 of what can happen at a termination trial or final hearing is permanent managing conservatorship to DFPS without termination of a parent's rights. This can occur in a variety of scenarios. It's possible when DFPS doesn't have enough to pursue termination, but is not okay with returning the children to the parents at that time, and there's not other options for shared custody between a parent and a non-parent outside of DFPS. This can occur regardless of whether a child is placed with foster parents or relatives. I've sometimes seen it occur in cases where termination isn't viable for reasons other than evidence. Maybe DFPS bungled something like service to all parents and the deadline is up, or parties don't want to pursue termination for another reason. This scenario can also occur when parties are waiting for the timeline of when Permanency Care Assistance, PCA, can be negotiated with a caregiver, but the TMC deadline is up, so a permanent decision has to be made. Generally, lots of advocates in this world are not huge fans of young children in the permanent custody of DPS, unless they're waiting for PCA, right? Without termination of parental rights, because it's a final order. People get very confused about what that means since there are still hearings going on, but it's just like regular family law. If you want to change a final order, you need a change in circumstances or something new that's happened after that final order. Because once children are in the permanent custody of CPS, there is no deadline, right? That statutory deadline only applies to TMC cases. So there is no final hearing set for something else unless someone files a modification, and there'll continue to be hearings every 6 months to check in on the kids because CPS is their parent. The thing to understand about children in the permanent custody of DFPS who are not awaiting adoption, right? And remember, if rights aren't terminated, there's no option for adoption. So important thing to remember is that children will stay in the permanent custody of DFPS until the final order granting them conservatorship is modified or until children age out of care. DFPS continues to look for relatives or other placement options for children in their permanent custody if an option hasn't been identified. But this is the second option that could happen at a trial. And then option number 3. Trial court can also decide to order a PMC to a non-parent at that final hearing or trial, with or without termination of parental rights. If this is ordered at the end of a TMC case, then DFPS is dismissed as a party. There is no court oversight continuing, and all court-appointed ad litems are dismissed. Sometimes this happens because the non-parent was the placement and wouldn't qualify for adoption due to something in their background. There aren't verification rules to grant custody to a non-parent if you're not looking at PCA, like there are for the non-parent to be a placement in a TMC or PMC case or to adopt. Some situations I've seen is a grandparent with old history that's a bar to adoption, but a judge is comfortable giving permanent custody instead of adoption. And so that can happen at that time. Sometimes this occurs when rights have been terminated, so it's just the non-parent with custody rights. I would say more common is that parents and non-parents share custody like a divorce when parents' rights aren't terminated. And like all final orders, those orders remain in place unless and until someone files a modification and a judge modifies those orders. And to be clear, agreements outside of court are not a modification. Just like only a court can order custody, only a court can change those orders with new orders. Some other things to understand about this option, PMC to a non-parent can happen again, which we're talking about at the end of a TMC case at a trial or a final hearing, or later upon a modification of the PMC case, when someone modifies or requests to modify those orders to transfer custody from CPS to a non-parent. In the next section, we'll get into the differences in benefits from PMC versus adoption versus permanency care assistance. What's important to note here is the law changed in 2015 and again in 2021 to require that, first of all, the department is telling non-parents about the differences in benefits and rights during a TMC case, but also number two, that the court is verifying that the department did that. Do I think this is happening everywhere? No, not with the calls we get to the helpline. And if it is happening, there's not enough explanation to families about what these different options are because there is a lot of confusion. So now we're flipping to the second part of this presentation, which is discussing the differences in benefits, depending on what type of custody somebody has. And so this slide, the post-permanency managing conservatorship payment, is for non-parents in the previous slide, where they were awarded PMC of the child and DFPS is dismissed, right? So there is no more oversight. CPS is not involved unless a new allegation is called in and a new case is filed. No one's monitoring the family or providing for the child's needs and health insurance like when the child was in the temporary custody of CPS. This post-permanency managing conservatorship payment is an annual reimbursement of up to $500. That's for 3 years or until the child turns 18, whichever comes first. I highly encourage anyone in this situation to look at the education code tuition and fee waivers. I cited the specific section that applies in this situation, and this code section, right, Texas Education Code 54.366, is specific to tuition and fee waivers for students who are currently under DFPS conservatorship or were at one point. Several of the scenarios in this code section can be a little confusing when you first looked at it, right? But several of those scenarios in that code section are based on age of the child or other factors. The specific code section that I cited in this last bullet point here is for children that were in DFPS custody, and then a non-parent took custody after 2009. And there's no age requirement for children in that situation with the fee waiver. Specifically, what the code says is, quote, a student is exempt from the payment of tuition and fees, including tuition and fees charged by an institution of higher education, if the student was under the conservatorship of the Department of Family and Protective Services on the day preceding the date permanent managing conservatorship of the student is awarded to a person other than the student's parents, if that date was after September 1st of 2009. So this was a new law in 2009. As you can see, this does not work for private custody cases involving a non-parent when the child was not in CPS's custody. Non-parents in these situations are on their own for health insurance or Medicaid applications. All right, I have a fair amount to say about Permanency Care Assistance, or PCA. Give me 1 second. So if PCA is awarded, there's no adoption. A non-parent assumes permanent custody of a child in this situation, but is given only the rights in the custody order and not the complete rights of a parent conveyed by adoption. So PCA goes along with PMC. The difference is from this slide and the last one, this has to be negotiated and there are requirements. So the first thing is understanding who's eligible. First, Caregivers who apply must be related to or have a long-standing relationship with the child or children before the child is placed there. Excuse me. So this is not for placements who did not know the children before placement in the CPS case occurred. Second, that caregiver applying for PCA benefits must be verified by a child placing agency. A court's order for placement with a caregiver is not enough to qualify for PCA. The caregiver must go through the verification process. Third, the caregiver must be a placement for the child for at least 6 months after verification before the court awards PMC to that caregiver and dismisses CPS and the rest of the case. And again, a court can't order around these conditions. There's a lot of things that are CPS policy that a judge can order around, but PCA and the way it's written into the law and how it stems from the federal law is not something that can be ordered around, from my understanding. All right, so the verification followed by 6 months of placement is the part that causes issues for lots of placements because of the statutory deadline we talked about, right? So the caregiver has to get verified, and then the child or children have to still be in that home as a placement for 6 months before PCA can occur. And because of that timeline, that's why there's a law that the court must inform relative and designated caregivers serving as placement for a child of their ability to become verified and apply for PCA. And the court, under the current law and the family code, is required to do that at the adversary hearing, the status hearing, and all the permanency hearings. And what they're trying to do, I assume, right, is ensure that someone does not take PMC of a child and provide for everything on their own when there is financial available assistance through PCA. There's just requirements and a timeline that have to be met. Before awarding PMC to a kinship caregiver under Permanency Care Assistance and dismissing DFPS from a case, right, the court should ensure that DFPS has determined that reunification is not appropriate and that adoption is not appropriate. If adoption was appropriate, they're going to go that route, and if they can, instead of PCA. And reunification with a parent does not allow for PCA. The children have to have been in the TMC or PMC of the department on the day before PMC is transferred to a relative. So again, this is not for private custody cases when the children are not currently in CPS's custody. If PCA is awarded, a final order is entered and CPS is dismissed, just like when PMC is given to a non-parent without PCA. The difference here is PCA has to be negotiated, and so that non-parent caregiver knows what they're entitled to, right, for the remainder of that child's young life. There are not ongoing hearings because the children are not in CPS custody once PCA is transferred, once PMC is transferred. PCA requires a final order as well. Again, cannot overstate this enough. Once PMC is transferred to that caregiver in a PCA case, there's no oversight by the court. CPS is not involved unless a new case is called in. There's no attorneys or advocates for the children. You can read more about PCA in the Texas Family Code. The specific section is 264.851. So why does this matter, right? It doesn't require termination and adoption, but the monthly stipend, health insurance, and tuition waiver are equivalent. I really want people to understand that this is an option. I want caregivers to understand that this is an option as well. And the only way to do that is just to continue educating people of its existence and where they can reach out for assistance. Something else to note, that is a sibling is placed by the department in the same home of a child who's already the subject of a PCA agreement, that caregiver automatically meets the definition of relative or fictive kin. There's a lot more I could tell you about this, but basically I would just want you all to be aware that a PCA successor can be designated at the time that PCA is negotiated. There are some other requirements to that, right? But basically that anticipates that if perhaps it's somebody who's a little bit older initially taking permanent custody and receiving PCA, that is a time to discuss who else could possibly have that child later in life as well. And so please, please, please know of this existence of PCA. Just a note on verification requirements. These have changed a lot in the last few years to be much less stringent on kinship homes. Please do not be discouraged if licensing seems overwhelming. The newer kinship separate standards help reduce barriers to verification for kinship providers. This is a link to find a child placing agency if you are interested in getting verified. Truly, these requirements used to be much more rigorous, but there's been so much effort by DFPS's kinship caseworkers and state office to reduce the barriers to kinship caregivers becoming verified so they can have financial assistance and health insurance for children they're raising. All right. As far as adoption benefits, the court again has no authority to proceed with adoption unless all parental rights have been terminated. Unless waived by a court, the petition for adoption can be heard and the adoption ordered after the child's lived in the adoptive home for 6 months. Just of note here, adoption benefits are not provided for every child who's adopted from a CPS case. DFPS has an adoption assistance program to help defray some of the costs associated with adoption of a child with special needs. Just want to note on here, highly recommend looking at the links if you are interested in more information. Definition of special needs is much broader than people might think. As it's defined on the department's website currently, special needs means at the time the adoptive placement agreement is signed, the child is less than 18 years old and meets at least one of the following conditions. Child's at least 6 years old, the child's at least 2 years old and a member of a racial or ethnic group that exits foster care at a slower pace than other racial or ethnic groups. Third, the child is being adopted with a sibling or to join a sibling or for whom the parents already have PMC or an equivalent arrangement in another state. Fourth, the child has a verifiable physical, mental, or emotional disabling condition as established by qualified professionals. Fifth, if I've lost count, the child has been determined by the Social Security Administration to meet all the medical or disability requirements with respect to eligibility for SSI. So again, just wanted you all to know that there's more to it for the adoption benefits as well. But if those are granted or negotiated, then medical assistance is available generally through Medicaid. There's reimbursement for certain one-time expenses relating to completing the adoption of the child. That provides reimbursement up to $1,200 per child. And there's monthly payments through the monthly adoption assistance payments, and those are determined based on the child's needs and paid to the caregiver directly. As far as post-adopt services, we do get a fair amount of questions about this. And again, just wanted to have this slide up so you know where to look. Post-adoption services are available to families at no cost after a child has been adopted from DFPS. Those services are provided to help the child and the family adjust to the adoption, cope with the history. Some of those services include casework services and case planning, support groups, skill building, counseling services, respite care, and residential placement services in critical needs situations. It also can include crisis intervention. And just to note about this, and I took this directly from the department's website, I think it's important to emphasize, post-adoption services are preventative, responsive, and family-centered. They are not a sign that something is wrong. They're supposed to help with tools to strengthen those relationships. Okay. That wraps up the first two parts of our presentation. I just wanted to run through some options if you've got additional questions. The first program I wanted to let you know about is our Family Helpline. We are all lawyers with experience in child welfare cases who answer these calls. You can be anonymous to us. We only collect a few questions of demographic information, but no identifying information. We provide legal information only, but we can answer most questions about an open or closed CPS case or law or policy or CPS process. We get plenty of calls from kinship caregivers who have questions about what is happening on a current CPS case, either when they're the placement or they want to know what options are now that maybe a CPS case is closed, but they're left with the children in the home. I suggest this is your first step because we try to answer calls live, and if not, we try to get back to everyone in a business day, and we can also refer you out for additional assistance if we're aware of resources in your area. I also wanted to highlight our Kin Care project, which helps non-parent caregivers. We say gain long-term safety and security for themselves and their children. This is how you apply. All of this information is on our website as well, TLSC.org. Of note here, eligibility requirements, you need to be a non-parent caregiver with a child that's not yours that you're taking care of. CPS involvement is not required for this. What I want to highlight on here, right, is we don't do adoptions or terminations or contested custody cases against parents. We can do any of the following that's listed on here, as long as someone is 200% or below in household income of the federal poverty guidelines. Do a lot of authorizations on this team, non-parent caregiver authorizations that aren't custody but can still provide medical and educational authorizations. We can help public benefits, social security issues, getting identification or documents for the child. I'm just going to flip back and show you. You can call this number or send an email. Also on our website at TLSC.org, there's a place you can fill an online form on and request that we call you. The last thing I wanted to show is we also have a bunch of resources for people who want to handle it on their own. We have a revamped kin care guide that was released last fall, Navigating Kinship Care in Texas. It does go through a few things CPS, but the bulk of it is about other options and resources that are available. You can find that on texaslawhelp.org. There's also plenty of non-parent authorization forms and guides if you are proceeding your own legally. You can also find those at texaslawhelp.org. All right, here's the final survey with the same 3 questions for anyone who's willing to take it, especially if you took the first one. Again, completely optional. I'm going to leave this up just for a minute and then I'll close it out so we can see if there's any questions we can answer. Okay, as long as you've got that on your screen, you can go ahead and answer that whenever. Okay, I do not see any questions in the Q&A, and I just want to check very quickly with Deanna and Stefan about whether there's anything they want to correct me on or otherwise share or resources, anything like that.
Nothing that I can note. I was just gonna say that there's also a podcast that is actually on our logo right here, the Kinship Chronicles. For anybody on here, if you want to check that out, it's a podcast that's for the public, and it is something that we highlight topics for kinship caregivers and informal and formal caregivers. So just throwing that out there as a plug. But I don't have anything else to add to your presentation, Cindy. That was great.
Thanks. Deanna, anything on you? Not to
I just
spotlight
want,
you, but
I just wanted to add that podcast can be found on YouTube.
all right. Well, thank you all for joining us. Again, this will be posted to our YouTube link on the TLSC website, and feel free to join us for our remaining webinars. Thank you too so much for joining us and just for all the work that you do. We very much appreciate you.